In room 226 of the Dirksen building in Washington tomorrow, the Senate Judiciary Committee will consider whether to protect some of America's most powerful corporate executives from the legal consequences of having spied on the rest of us in this country. And on our third story tonight, an AT&T whistleblower today told members of Congress much more than that is at stake with the secret crimes that took place at room 641A of AT&T's Folsom Street facility in San Francisco and potentially at others across the country. Specifically, retired 22-year AT&T technician Mark Klein says that despite Mr. Bush's claims, the U.S. government used AT&T's cooperation to spy not only on overseas communications, but to vacuum up virtually all of America's use of the internet for years. Email, Googling, web surfing, you name it. Thanks to AT&T secure rooms like 641A in San Francisco, accessible only to those cleared by the NSA. Klein obtaining AT&T schematics showing how the company used splitters to send secure room 641A a duplicate of every fiber optic signal routed through its facilities. And involved not just AT&T customers, but virtually every internet and telecommunications company, and virtually all email and web traffic in the country, without a warrant, without any mechanism for separating domestic from overseas, without separating suspect from citizen. We welcome now former AT&T technician Mark Klein, whose documentation and claims are now part of a class action lawsuit against AT&T, one of 38 telecom spy lawsuits, AT&T so far declining to comment on the specifics of these allegations. Mr. Klein, great, thanks for speaking out tonight.
Thanks for inviting me.
The Senate is considering granting the telecom executives immunity. You lobbied Congress today not to do so. How come?
Well, if they give them immunity, it would probably shut down the lawsuit that I'm a witness for, and then the American people won't find out what's really going on. And so that's why I'm here, to stop immunity. Congress should let the judicial process go forward.
Two-parter here. First, can you explain to those of us who can use the internet but would not be able to tell the difference between its physical form and, you know, a box full of guitar strings, exactly what happened in that secure room or secret room, 641A?
I don't know what goes on in the secret room because I didn't have security clearance, but I know what went on outside because my job, I worked in the internet room. My job was to connect circuits into the splitter device, which was hardwired to the secret room. And effectively, the splitter copied the entire data stream of those internet cables into the secret room. And we're talking about phone conversations, email, web browsing, everything that goes across the internet. And that device, the splitters, is a dumb device. It doesn't do any selection at all.
And the follow-up to that, as you mentioned, you didn't have the security, the NSA clearance. So give us an idea how you know all this, in addition, obviously, to your expertise as a technician.
Well, as a technician, I had the engineering wiring documents, which told me how the splitter was wired to the secret room. And so I had to know that in order to do my job. And so I know that whatever went across those cables was copied in the entire data stream was copied into the secret room. The splitter device has no selective capability, it just copies everything. And we're talking about domestic traffic as well as international traffic. And that's what got me upset to begin with.
Yeah, I was just going to say, Mr. Klein, this huge distinction the White House made when all this was first revealed, what its defenders still say, oh, we're just intercepting international communications, no domestic communications were affected. I'm taking you don't buy that in the slightest.
No, I know that wasn't true. And that's what got me going in December '05 when the New York Times revealed this, and then the administration came back, the president himself and his various cabinet people trying to argue, and they still do, that it's just international communications. It just affects a handful of people who are making phone calls to the Middle East. And I know the physical equipment, and I know that statement is not true. It involves millions of communications, a lot of it domestic communications that they're copying wholesale, sweeping up into that secret room.
When you saw this and realized what was going on, what was this like? Was this like sitting there and finding yourself in a scene from the sci-fi flick Invasion of the Body Snatchers? Did it have that sort of hard quality to it?
Well, I had this, actually, I'm a little older, so my thought was George Orwell's 1984, and here I am being forced to connect the Big Brother machine.
Oh boy.
And I felt that I was in a funny position, but I needed my job, so I didn't want to make a fuss at the time. But after I retired, I thought about it some more.
In talking to Congress today, what did you hear? Did you get a sense that anybody's prepared to go after not just the telecom execs, but the government officials who ordered this?
I couldn't tell. I'm not a politician, and they play their cards close to the vest. All I can do is emphasize again that they're copying everything. This is a violation of the Constitution. It's domestic traffic. It's phone calls as well as email, and something should be done to stop it. And Congress should not kill the judicial process.
The nice thing is that if there is anything that's going to stop it, it's going to be because people like you have the courage to do something about it. Mark Klein, formerly of AT&T, great thanks for joining us, and great thanks for what you're doing. For those in power, the obvious advantage of keeping people in fear is that they are less likely to question what you then do to them, purportedly in the name of their own security. The hidden but perhaps greater advantage is that if any of them do ask you what you're doing, you can reply, "Can't tell you," because that could compromise your security. Thus has the Bush administration not only eavesdropped illegally on Americans, but it is also hidden behind the state secrets claim when its illegal wiretaps have been challenged in court. Let's turn to constitutional law scholar Jonathan Turley, professor at George Washington University. John, good evening.
Hi, Keith.
Am I wrong about this? I mean, if you strip the politics away somehow from this and you asked every American about this topic, wouldn't they assume that this already was a law, that the government has to make at least some token effort to justify acting in secret against its own citizens?
Well, it actually is the law. You know, this has been a distortion or a mutation of the law. The privilege has become something that I think the Supreme Court never imagined when it first created it in a case called Reynolds. They stated in Reynolds they expected judges to try to minimize the scope of the privilege. But today, the privilege is used primarily not to keep something secret, but to keep something from being used against the government. In litigation like the Area 51 case that I litigated, we had a report that showed the government was lying. The court had the report, I had the report, the government had the report, but what the government didn't want is for the report to actually be used to prove that they're lying. And we've seen that in case after case. I was in a courtroom when people laughed when the government counsel argued that they could use the privilege to claim as secret something that was published on the cover of the New York Times. That's how grotesque the privilege has become.
Hence that phrase laughed out of the court. But as the Associated Press reported, some judges are already taking it upon themselves to, I guess, adhere to the original idea of the law and evaluate these secrecy claims by the administration. Why don't all of them do that?
I'm afraid part of the answer is that some judges are lazy, and some judges are not fulfilling their what should be a sacred duty as an Article III judge. You're given life tenure so that you shouldn't be afraid. But many judges just simply use this as an easy way to get out of a difficult problem. I have been in cases where the government was most clearly and certainly lying to the court, and the court did nothing to look at whether that allegation was true. And I think that's why congressional action is so needed here. You know, Reynolds itself, the original case, was built on a lie. It was, at the time, people believed the Air Force had lied to the court. Many years later, the family showed it was a lie, and a few years ago went back to the Supreme Court and said, look, here's the proof that you based this decision on a false representation by the government. And the Supreme Court refused to re-examine the case.
All right, with or without this new law, suppose one of the anti-wiretapping civil lawsuits succeeds. What does that legal victory actually mean then in terms of stopping the government or punishing Alberto Gonzales or any other top officials who were responsible for this?
Well, it could mean a lot, and that's one of the reasons there's a lot of people, both Democrats and Republicans, that don't want to see it happen. They don't want a court to say that the president did something that is a federal crime. That's why they're trying to get all these cases thrown out of court, because it is rather clear that what the president ordered was a federal crime, clearly defined in federal law. But that causes a problem, because many of the Democratic leaders and Republican leaders have promised each other that they would not start impeachment proceedings. But when a federal judge says the president committed a crime, it's pretty darn hard to ignore that.
Unless everything gets tabled until 2009, and let's say that this law does become the law of the land officially again, even though it's already on the books, the first act signed by President X in February 2009, would it offer a tool for prying the lid off some of the Bush administration's secrets sort of after the fact?
It would. Keith, if I could get one wish granted, it would probably be this, that we could put this genie back in the bottle in terms of the privilege and allow citizens to sue their government to prove things like crimes. If you look back at history, most of the great reforms were not brought forth by Congress or presidents. They were brought forth by citizens standing up to the government. The privilege is now a tool used to protect the government from its own crimes, and that's what we need to work on.
Professor Jonathan Turley of George Washington University, as always, sir, most harrowing, and great thanks anyway.
Thank you, Keith.